1 of 2024, State versus Danny Jordaan, Trevor Mifflin, Ron Fuyo, and Rail Communications Pty Limited, represented by Trevor Mifflin, number 2.
My lady, I appear again this morning. Good morning. For Mr. Jordaan and Mr. Schlo, accused 1 and 3, instructed by Victor Kwashu, my attorney.
I appear for accused 2 and 4, Your Worship.
As a purpose, Your Worship, this matter was remanded on the last occasions for purpose of the counsels for accused to take instructions and let the counsel address the court as far as that is concerned.
My lady, just to start with maybe at the back end, we have secured further dates in this matter for Friday the 15th of August. We agree a longer postponement because there's a number of things that have happened and that's expected to happen. Firstly, we have respectfully disagreed with your ruling on the 10th of December, and we filed an application to review that decision. Those papers were issued yesterday. I think they have been served on you, so that inevitably will result in a delay. Yesterday, we received an amended charge sheet, charges 5 to 7 in respect of my clients accused 1 and 3 have been withdrawn, and that relates to allegations of theft in an amount of 888,335 rand 5 cents, and those charges have been withdrawn. So we sit now with hopefully a final charge sheet. We obviously have some pre-trial rights in respect of requesting further particulars, so that is likely to happen, and depending on that, we may want to also proceed to make representations to the Director of Public Prosecutions to have the charges withdrawn. My colleague for accused 2 and 4 will address you on the latest development in the representations that they made and the exchange of correspondence between him and Mr. Chowki, the provincial director of South Gauteng, which again will inevitably involve some further delays. So, my lady, on that basis, we've agreed to postpone the matter. Just from our side, my lady, I want to request, and hopefully my colleague will agree, is that the one condition that is in respect of Mr. Jordaan, the one that requires him to report his travel arrangements, that condition be relaxed. He has committed himself to do it. He's done it several times. He remains a special advisor to the President of CAF and to the Executive, and sometimes arrangements have to be made at short notice. And I recall personally from a few weeks ago, he was quite panicky because he wasn't able to get hold of my learned friend, the prosecutor, and of my instructing attorney. It was an awkward time of the year, and do I go, don't I go? We don't think there's any prejudice that this condition be relaxed or removed. He has paid his bail and remains on bail, my lady. As the court pleases.
Which condition is it?
This is the condition that requires Mr. Jordaan to indicate 72 hours in advance the traveller. It's not for, to be clear, it's not for permission for him to travel. It's just that he must indicate his travel arrangement 72 hours before the time. And as most of soccer people involved in the administration of the game, sometimes these things are arranged at the last minute, and it's not possible to stick to that 72-hour arrangement. But we feel he has complied up to now. He's shown his willingness to do so. He's not going to go anywhere, and it should just be removed in its entirety, my lady. As the court pleases.
Mr. Ndebele?
As the court pleases, Your Worship, with regards to accused 2 and 4, representations were made to the Director of Public Prosecutions in accordance with the provisions of Section 24B of the National Prosecuting Authority Act. Such representations were submitted on the 23rd of January 2025. On the 24th of January 2025, Advocate Chauke himself acknowledged receipt of the representations and gave an undertaking that he will require until the first week of March this year to properly consider the representations and make an informed decision with regards to the representations. Yesterday, Your Worship, Advocate Chauke again sent me correspondence requesting to establish whether or not I intended to supplement the representations. A response was provided to Advocate Chauke yesterday indicating that the preliminary representations read with the representations that were transmitted to him on the 23rd of January were final representations, so there will be no supplementation thereof. Insofar as the date that has been arranged with the State, Your Worship, the defense for accused 2 and 4 agreed to the 15th of August in anticipation that should Advocate Chauke decide to withdraw the charges, the matter will be brought forward by arrangement with the State insofar as the matter is concerned. We will not have to wait until August for that matter to be finalized. So subject to the decision, Your Worship, however, I do confirm the 15th of August. I'm not so sure what I think it's just to allow the interlocutory applications as well as the decision to be made insofar as representations or possible representations for accused number 1 and 3, Your Worship. The accused number 2 is on bail. I'll request that his bail be extended and he be forewarned for the 15th of August. However, bearing in mind, should the outcome be favorable, we'll be here sooner than then, Your Worship, as the court pleases.
Advocate Malebati?
As a court, Your Worship. Your Worship, up until this morning, I wasn't aware that there is a review application by accused 1 and 3. The else, I realized that I have been sent an email which was transmitted at 4 o'clock yesterday afternoon. And unfortunately, at around 5 to 4, I packed my things, and the email was on the dot, 4 o'clock on the dot. So it's about the review application regarding your worship's decision on the last occasion. And based on that, this morning we deliberated and decided we should have a longer remand for this issue to be decided. I believe it will take some time. In the timelines, some of the requested return dates go up to April, if I'm not mistaken, so it will take some time to worship. And again, Mr. Ndebele also sent his request for the review of Advocate Nkona's decision to dismiss their representations on the last occasion. And unfortunately, there was a correspondence between Mr. Ndebele and the DPP on which I was not copied, but I do not take offense of that. Only to say that I was very aware of the correspondence between the two. But then based on their correspondence, Your Worship, it would appear this will take some time. I've had sight of those observations, and they would naturally require the state to respond, verifying some of the allegations and claims therein, which would naturally also mean or necessitate further investigation into those claims. So that on its own will mean we'll have to take some time before the DPP can make a decision. So I believe the date of the 15th of August 2025 is long enough, and by that return date, I believe everything will have been sorted out. So the state has no objection, and if the matter is remanded to that date. And as far as the charges 5, 6, and 7 are concerned, it's indeed true that the state had revised its charge sheet and removed charges 5, 6, and 7 relating to the theft of the 888,000. However, the remaining 4 charges remain: the charges of conspiracy to commit fraud and theft, the charges of fraud and alternative theft remain in respect of the amount of 1,150,000 as well as the 40,250 rands. They still remain in worship. Now, in as far as the bail conditions are concerned, the state is objecting to the relaxation of those bail conditions. We've had quite a lengthy address in as far as those are concerned during the bail application, and this was kind of struck as a compromise position that the accused number 1 would report 72 hours before departing Your Worship, as the state was completely opposed to him even departing the country, and the court decided it should make a condition that he reports at least 72 hours. He may be allowed to depart the country, but should report 72 hours before doing so, Your Worship. And it's based on the wisdom of the deciding officer during bail application that this condition is was made and imposed, Your Worship. And I believe this matter should rather be reverted back to the presiding officer who dealt with this issue, Your Worship. But as a state, we believe the condition should remain. And the fact that accused only traveled twice, I believe, and I submit, is not enough, or rather doesn't remove the need for that condition. That condition has been made for a reason as a condition.
Just to deal with that application that is coming through for the amendment of bail condition in respect of accused number 1, I suggest that a proper application be brought before this court. I don't know how the court that dealt with the bail application arrived to that condition. So a proper application for that condition to be relaxed needs to be brought before court in terms of Section 63, because what I'm saying is that the bail application was made under the affidavit was used, which is a form of evidence. But now you're addressing me from the sidebar, and you did not dwell much. How did the court arrived to that condition? So this court is not privy to the bail application as to how it was conducted. So basically, I would say that a proper application in the form of affidavit at least be brought before court in terms of Section 63 of the Criminal Procedure Act, so that the state also can be given a chance to be able to respond to that application.
As your Lordship pleases, that's why I asked for reason to prevail, and that my colleague will agree to and make it a joint request to you to avoid bringing a formal application, my lady. But,
even for the court,
I think your Ladyship's point is that if we must bring a formal application,
yes,
it must be brought on affidavit or evidence.
Yes.
I accept that.
Thank you. Advocate Malebati, basically these charges are not, you remove them, there's no need to withdraw those charges as the court. 5, 6, and 7, you have removed, you're not going to proceed with them.
Yes.
So there's no need to withdraw them. Right, thank you. All right, the court, I will state that I have not been served with that review application. I'm also surprised, like the state is indicating, but I'll wait for the service to be done of the review application. But in this court for now, I'm going to request the 3 gentlemen to rise so that I can postpone your matter. Your matter is postponed until the 15th of August, back to court number 9 at 8:30. It is for the outcome of representations. Accused 1 to 3, bail extended with the same conditions, and you are warned back to court number 9, SABC. I did not note the review. The review is running on its own. I'm running with what is before me. All right. So if we are served, then the review will proceed. But for now, I just make sure that it's postponed, at least in respect of accused number 2 and 4, to know that it's just for the outcome as well of representations. All right. Thank you.
As the court please. May we excuse?
You're excused.
Thank you.
Excused.